Hi, I'm Barry Smith. I go by Legal Bear on the internet. Sometime around 1990, I heard from the creator. He says to me, get a computer, learn how to use it, and start studying law full time. I estimated that I studied law for 40 hours a week for about 10 years. And during that time, I met up with a professional video producer, and we went into several law libraries, and we made a professional video on how to use the law library and do legal research. And I got a lot of compliments on that. In fact, one paralegal that had been to paralegal school told me we should have used that video in our school. Then sometime around 1997, I learned that continuing legal education here in Colorado was doing a legal research on the internet class, and I succeeded in enrolling in that and taking it. And then sometime around 1998, I started doing all my legal research on the net, and I made a legal research video on how to do internet legal research. Sometime during the course of my working with the law, I had dealings. I helped a guy who was dealing with Idaho courts. They were trying to make him file tax returns using a mandamus proceeding under Idaho law. So I wrote a memorandum supporting a motion to dismiss to show what they were doing was illegal under the U.S. Constitution. I knew about that this was possible from a case called Davis versus Wessler, where the U.S. Supreme Court said that it's possible for the state to put a snare in the front of a constitutional right. And in that memorandum, I pointed out that the U.S. Supreme Court had already ruled a long, long time ago, back in the 1800s, that compulsory production of a man's private papers to establish a criminal charge against him or to forfeit his property is within the scope of the Fourth Amendment. Now, think about that for a sec. Ever notice that a cop asks to see driver's license, proof of insurance, and registration? He asks to see it. Since a cop asks, that is not the compulsory production of a man's private papers. And when you provide them, you just relieved him of his duty to have probable cause in order to see them pursuant to the Fourth Amendment. Like sometimes I like to ask the cop, hey, if you had to go to a court to get a warrant, what would you have to tell them? You would have to tell them the place to be searched and the thing to be seized, because you can't tell them, you can't go house to house in whatever city you're in looking for my driver's license, proof of insurance, and registration. They just won't let you do that, right? So that means you have to know whether I have one, where it is, what house I keep it in, and so forth, before you can get a warrant. And you don't know those things. You don't know whether I have one or not. You don't know whether my insurance is current. You don't know where I keep it, the place to be searched. You don't know if I keep it in my car, in my house, or in my billfold. And so you wouldn't be able to get a warrant. Okay, so then if there's anything wrong with those papers, you just cooperated in your own prosecution when you didn't have to. Miranda versus Arizona, the U.S. Supreme Court said, police must solve crimes by their own efforts. What that means is you don't have to help them. And you know what? You don't have to help them even if state law says you have to help them, because the U.S. Constitution says you don't. And it's the supreme law of the land in America. So if you look at these same principles hold true for the IRS. In fact, the case that was the foundation for the memorandum was a Supreme Court case. And basically, that case addressed penalties. Well, so much of what the IRS does, and for that matter, traffic too, involves penalties. If you look at the traffic tickets in Colorado, it says right on there, penalty assessment is on the ticket. So that their whole thing they're dealing with this penalties, and this U.S. Supreme Court decision addressed that they cannot compel you to provide papers that will result in a penalty. So the IRS comes around and says, where's your back tax returns? You know what's coming next is, since you didn't pay, you owe a penalty. The U.S. Supreme Court continued. I pointed out in the memorandum. The court, they're talking about a court's trying to do this. A court's supposed to know better. A court is sworn oath to uphold the Constitution's federal and state. And in this case, it was a federal court, I think, that attempted to extort from the party his private books and papers to make him liable for a penalty or to forfeit his property. Supreme Court, I point out, that's the Supreme Court previously said, claims overriding interests are not unusual in Fifth Amendment litigation, and they have not fared well. So they've been in there trying to say, well, you know, how are we going to enforce the law if the Fifth Amendment applies? And finding out, the court says, well, you do your best because it applies. U.S. Supreme Court, with respect to, let's see here, transportation laws. U.S. Supreme Court recognizes that without the compelled testimony of knowledgeable and perhaps implicated witnesses, so some witness is going to get himself prosecuted based on what his testimony is, the enforcement of transportation laws will become impossible. That's what they tried to claim, right? But in other words, the court recognized, yeah, that's true. But nevertheless, if they want that testimony, the court said the witnesses must be granted adequate immunity if their evidence was to be compelled. I also pointed out in that memorandum that the court specifically addressed the interplay of the taxing power and rights by saying, Congress is granted broad power to lay and collect taxes, but the taxing power, broad as it is, may not be invoked in such a way as to violate the privilege against self-incrimination. So there they are talking about, you know what, we have those rights, even in a tax case. I also pointed out that the Supreme Court said, we've been unable to perceive that the seizure of a man's private books and papers to be used in evidence against him is substantially different from compelling him to be a witness against himself. So, we have the cop standing at the window, asking for papers to be used in evidence against you, and asking for those papers equals asking you to be a witness against yourself. Why would you cooperate that? Why would you volunteer? Mostly because you don't know that you have a right. You think government officials probably are supposed to know what your rights are and honor them. I mean, after all, they are the ones that took an oath to uphold the constitutions. But that is not the case. We have to learn about these rights, and we have to assert them because we're knowledgeable. I pointed out, the Supreme Court said, a confession must not be extracted by any sort of threats or violence, however slight. The person must not have been compelled to incriminate himself. Well, I'll tell you what, every cop at the window is intimidating. Got their gun on their holster. They're trying to pretend like they're acting under the authority of the law, like they've got statutes that mean you must testify against yourself, contrary to the federal Constitution. And you need to learn to just shut all that down. And then, with respect to threat of arrest to compel your testimony, U.S. Supreme Court, which I pointed out in the memorandum, forbids the states to resort to imprisonment to compel him to answer questions that might incriminate him. So the cop can't say, if you won't show me your license, your proof of insurance and registration, you're going to jail. Wrong, and especially if you point out to the cop, I know what the U.S. Supreme Court said about this. The clearly established law is you cannot arrest me for asserting this right. I pointed this out in the memorandum. U.S. Supreme Court continues, we scored the assumption that those who claim this privilege are either criminals or perjurers. Now, what this means is that the taxman, the judges, the cops. This is telling them what the U.S. Constitution means. This is telling them what they swore that they would uphold. And the court's saying, nope, you can't presume that they're either a criminal or a perjurer just because they invoked the right. Supreme Court, I pointed out in the memorandum, privilege against self-incrimination would be reduced to a hollow mockery if its exercise should be taken as the equivalent either to a confession of guilt or a conclusive presumption of perjury. So, nope, they're not going to let them jump to those kind of conclusions. And if you let them jump to those kind of conclusions, then that comes down to you. So it took 10 pages to get those kind of things pointed out in the memorandum. I went on for 12 more pages with still more authority as to what our rights are. To order this memorandum and two others like it dealing with asserting your right to be free from compulsory servitude and your right not to identify yourself, look for links in the description of this video before. This memorandum was about Fourth and Fifth Amendments and how they combine together to keep you free from testifying against yourself in the form of documents.